2014, I didn't even have an opponent, so I didn't collect the money. So I think it's best that we proceed at this point in time. Do you have any matters in aggravation you wish to discuss?
Yes, Your Honor, by way of exhibits and argument. May I proceed?
You may.
Your Honor, the guilty plea in this case did happen in May. And if it's all right with the court, I would like to refresh the court's memory as to the factual basis that the state presented at that guilty plea.
If you would do so, please.
Your Honor, in the event of a trial of this matter, the state's evidence would show that on the date alleged in the indictment, a call came to the Columbus Police Department a little bit after midnight. They were actually contacted by Baptist Memorial Hospital. As the court knows, hospital personnel are mandatory reporters. They had the victim, Martha Hill Clark, as a patient in the ER. When they were taking her medical history and asked her what had happened, she indicated she had been in an altercation with her husband, Brian Clark, the defendant. She appeared at the ER with a number of lacerations as well as bruising. She had a black eye. She had a cut above her eyebrow. She had a small laceration on one side of her scalp, and the most notable injury was that the top of her head down the back of her scalp was split open, leaving a laceration that needed, I believe, 18 staples to close in her head. She reported to the medical personnel at Baptist that her husband had grabbed her hair and slammed her head both into the floor and into a door frame. Police responded both to the emergency room as well as the Clark's residence. At the residence, law enforcement officers took pictures of blood on the floor, blood on the door frame, bloody handprints on the glass of the door. There was a sufficient amount of blood, a large amount of blood on the bed sheets as well as in the bathtub. Ms. Clark gave a statement to law enforcement. She told them that she had been out to dinner with her husband. They had both been drinking. When they came home, she got in bed. At some point after she got in bed, they started arguing. Her statement to law enforcement officers was that Mr. Clark told her that she was stupid and that he didn't want her to be working anymore. She's a dentist who practices in Starkville. During the course of the argument, he grabbed her by the hair and dragged her out of bed. She repeatedly asked him to leave. There were 2 young children in the house that night. Her son from a previous marriage, who was 10 at the time, was at the house. He was awake and heard. I believe the court has already heard from him under seal today about what he remembers.
The court has heard, just sorry to put this on the record, the court has heard from Baker Hines, and Mr. Wright was present, you were present, and the court was present. She took down all questions and answers, and that will be under seal so that any review in court, if they need to review it, can. The court did hear from Mr. Hines.
May I proceed?
Yes, I'm sorry.
Okay, Your Honor, there was another child present that night. Dr. Clark and Mr. Brian Clark share a son, John Davis Clark. He was 18 months old at the time, too young to give any recollections to the court. Your Honor, Ms. Clark indicated that at some point when she was in the bathtub, Mr. Clark had dragged her to the bathroom and started trying to rinse her off to get the blood off of her. Her son, Baker, entered the bathroom. He then went into his room, and Brian Clark then left the bathroom to go toward the front of the house. At that time, the victim, Hope Clark, ran out of the house in a towel up the street to her mother's house where her mother and sister were. They took her to the ER. Your Honor, after she ran out of the house, the state's evidence at trial would show that Brian Clark then threw a bunch of his belongings into his vehicle and took the 18-month-old, put him in the car, and took off after admittingly having been drinking. Your Honor, while Martha Hope Clark was at the ER talking to law enforcement, her phone started ringing. Lieutenant Donnie Elkin was at the ER taking her statement and taking pictures. When the phone started ringing, it was Brian Clark, this defendant. Lieutenant Elkin answered that call and told Mr. Clark that he needed to come back to Columbus, that he needed to talk to them and potentially turn himself in. He refused. They then contacted the Waynesboro, Mississippi Sheriff's Department, who had to actually go to Mr. Clark's residence, arrange for a caretaker for their 18-month-old son who was at the residence, and bring Mr. Clark into custody. Mr. Clark protested, said he was innocent, that he was only trying to help his wife, and that she had fallen and hit her head in the door. The first item the state would present to the court for its consideration and aggravation is a composite exhibit. I do not have it stapled yet, but of 14 photographs showing the injuries and the scene at the house when law enforcement arrived that night.
Mr. Wright, have you seen these?
Yes, Your Honor, I've seen these pictures.
If you will let Ms. Alford borrow them for purposes of this sentence. May I?
May I proceed?
Yes, please.
Your Honor, Dr. Clark also indicated to officers at the hospital that night that her husband was on probation. She said for drinking and driving. The next item the state would present is a sentencing order out of Forest County, Mississippi, in cause number 2011-198CR, which is an order of non-adjudication and placement in a drug court program, just to show that at the time this occurred, Mr. Clark was under a 5-year non-adjudication, so he does not have a felony conviction at the time that this occurred. To the state's knowledge, nothing has happened in Forest County on this case. May I approach and ask this be marked as an exhibit?
You may, Mr. Wright, have you seen this document?
Yes, Your Honor, I have.
Let it be marked and received. Looks like you pledged a felony eluding.
Yes, Your Honor. May I proceed?
Yes, please.
Your Honor, I also looked at the pre-sentence investigation that was done right before the sentencing hearing today, and it indicated that there were no prior felonies, no prior misdemeanors. In all candor to the court, I do not know if this has been expunged. However, I would introduce the III that was a part of the discovery in this case on pages 86, 87, and 88, which shows misdemeanor arrests in Newport Beach, California, in which Mr. Clark was found guilty. He was sentenced to probation and jail. He had a probation violation. And that's in 2008, and another in 2009 for obstruction, DUI, and DUI alcohol drugs. And I asked the court to just look through this III because I think it does conflict with what's in the pre-sentence investigation.
All right. If you will, Mr. Wright, have you seen this?
Your Honor, it's in discovery, as Mr. Clemens pointed out, I'm well aware of it.
Okay, thank you. Let me mark and receive.
May I proceed?
Yes, please.
Your Honor, the last item that I would ask to introduce as an exhibit for the purposes of this hearing is a composite exhibit of a number of documents from the First Judicial Circuit Court of Okaloosa County, Florida, involving an Aaron Treadwell, who filed for a restraining order against Mr. Clark in 2016, alleging domestic violence. Your Honor, this composite exhibit includes certified copies of the court documents. It includes photographs of Ms. Treadwell's injuries. It includes text message exchanges between Aaron Treadwell and Brian Clark. All of these occurred subsequent to the date of the incident that we're here about today. I would ask the court to consider these items in reaching its decision today, as clearly domestic violence remains an issue for Mr. Clark. And again, I believe they're relevant because they occurred after, while he was awaiting disposition of this case, Your Honor. I'd ask that these be marked as an exhibit to this witness's testimony. I have provided copies to the defense counsel.
Your Honor, with regard to the judicial part of that composite exhibit, I would object because I don't think there's been any adjudication. That's hearsay. We don't have anybody here to say that has been finalized. With regard to the text messages, I can't object to those. The judicial part, I mean, we don't know what the outcome of that was, what the underlying facts are, or anything that's happened since. I have information what's happened since, but I don't feel that it's hearsay.
Your Honor, I believe the resolution is actually in these documents that the domestic violence restraining order timed out. Essentially, it was only in place for a certain amount of time. It was not renewed later. However, as the court is aware, the rules of evidence don't apply in a sentencing hearing. And the state's position is that it's important for the court to consider these items, as these are proof of Mr. Clark's conduct while awaiting the disposition of this case.
You can mark them, receive them, and I'll give them what weight credibility I think that they deserve under the circumstances. Generally, I prefer to have people on something like that get on the stand and testify.
Your Honor, Ms. Treadwell lives in Florida. She did write a letter that has been submitted to the court file.
Okay. There are a number of files, letters that have been coming in this morning that I have not had the opportunity to read yet, but I will read. You may let Ms. Alford mark and receive them, and I'll give them what way I think they should receive.
Your Honor, the only other thing I have is an argument. I don't know if the court prefers to hear that now or after Mr. Ray does any matters of litigation.
Why don't we do that afterwards? I'm looking at this triple I sheet, and it seems to sort of the same triple I, or triple I with an individual with the same identifying information. And Mr. Ray, the precedence doesn't show that there are any misdemeanors.
Your Honor, my client, when that was presented, it's his understanding those have been expunged. If the court would allow, I can confirm that.
Sure.
He certainly would have told Mr. Doble we had a discussion about that before that, but we're not trying to keep anything from the court.
No, I understand. It's the same identifying information, so I'm assuming it's probably the same individual. do you have any matters that you want the court to consider by way of mitigation?
Your Honor, based on my knowledge of how you do sentencing hearings and our discussions in chambers, I know that I'm not going to be allowed to put anything on that happened prior to this event. It's not relevant, and I understand that. So I would ask the court to consider the fact that my client has been in the bachelor's class in Pearl, Mississippi since May the 19th. When he pled May the 16th, I began researching because Ms. Clark asked for it's not an anger management, but a specific bachelor's syndrome class. And I looked all over the state. I found one that the circuit court in that district uses. And he went the first time he could go. I called the guy. He pled on the 16th and on the 19th. He's been every week thereafter. I believe that is attached to my motion for a continuance on August the 9th, the letter from the head of that class. Secondly, after this happened back in 2013, my client attended an anger management class and successfully completed that. And he will bring the court, he will provide the court other information at a statement he would like to make to the court prior to sentencing with regard to what he's tried to do since this awful event. And he's tried to make amends, and was evidenced by the anger management and evidenced by attending the bachelor's syndrome class. He would have gone to any class, whatever Ms. Clark wanted, he would have gone to that. And I wanted to help everybody involved in this case found that class. And I have been in contact with the person that runs it. He said that Mr. Clark he's been there every time. And I think that the continuous exhibit shows that. As Your Honor knows, and more than anyone, we do this all the time, in cases such as this, there's really not much we can do except present what we've done since then. And my client has engaged in anger management and the bachelor's class and tried to rectify what he is committed to with a bad decision to someone he actually loves and still does. And it's a terrible situation for all parties involved. So I guess I'm working into an argument. I don't think to do that. I know that you want to do that at the end. So
Sure. That's okay.
but I believe the court, I would ask you to take judicial notice in the file of the bachelor's information. That is the most relevant and timely thing with regard to my client's efforts to make amends for the situation. And he will have a statement for the court at the appropriate time.
Do you have any witnesses you wish?
I do not, Your Honor. Based on what I said previously to the court, that everything that I have is this. I know this court would deem irrelevant to why we're here now.
Anything? What I want to do is I've been getting letters all throughout this morning, apparently. I signed for one yesterday that came, return receipt requested. I think Ms. Connor, did you get one yesterday too? And it's, I gave it to her, it's in the file. So there's things in here that I've not read that I'd like to look at. Did we get one this morning that was return receipt requested too?
No, the FedEx is in it.
FedEx, it's in here. So we've been getting lots of letters. As I told y'all, in almost 15 years of being a judge, I've never had this much interest from just regular folks about a sentence. And I started getting, our office started getting phone calls around the 10th of August. So, some of these are signed, some of them are not. Some of them tell me where they live, some of them don't. And they all seem to have a story. Have y'all had a chance to look at these?
Your Honor, I have not.
Some of them I know you couldn't because they've just come in today.
And Your Honor, also, I would ask you to take additional notice of the letters I provided today, too. I provided a stack today, so
Yes.
I know you probably haven't had a chance to do those.
They're in the file, and that's why I want to take everything. Why don't y'all, what I'm going to do is I want to look at these, and I want to read these first. And then I want to read these letters. While I'm back in chambers reading these, because I'm going to take a break, why don't y'all take time to look at these letters that are in the file, if y'all want, because they go back a ways. There's letters.
I've reviewed them, Your Honor. I pulled the file yesterday afternoon and reviewed those that were filed at the end of the day yesterday, and this morning, I read the ones that were submitted this morning as well as those that Mr. Gray submitted.
And I'm given to understand, Dr. Clark still doesn't want to tell me what she thinks is an appropriate sentence. Is that right?
Your Honor, I spoke with her this morning. She does have her victim's impact statement that is filed in the court file. When it comes down to it, Your Honor, she feels that when she gets on the stand, nerves, pressure, whatever else, prevent her from being able to speak clearly about what she wants to have happen. And in part, that is because she does not know. She said this morning, I want Judge Kitchens to decide because I am too emotionally entangled. This is not just her husband. He is still her husband. But they share a child together. So whatever happens to Mr. Clark happens to the father of her children. She has done a lot of research, a lot of reading about domestic violence. She said, I am a battered spouse. I still love him, but this has to stop. And the state has very strong feelings about that and would like to speak to the court on that. I don't know if you want to hear that before you review letters or not.
Let me review letters before, but in regards to what you're saying, I think Dr. Clark and Mr. Clark were visiting this morning back in the witness area. Is that correct?
That's what I was told. I was not there, Your Honor. I was in chambers with the court when that occurred. And again, what her response was, it's too difficult for her because she is still emotionally involved with the defendant. They are not back together. They are not cohabitating.
The court understands the difficulty because they have a child, and as I spent in painful detail last week explaining cases that I've dealt with, including the couple that I still see at Walmart most every Sunday, and she shot him
Right.
in the shoulder, and they're still together, so I understand.
I think Dr. Clark is having a conflict between her emotions in her head because she is an intellectual person. She's a physician. She understands that her emotional entanglement with the defendant is something that is a symptom of this issue, this domestic violence as a whole. She does not want it to be just a slap on the wrist, but it is next to impossible for her to actually say out loud that she wants him to get the maximum sentence as well, because they are married and they do have a child together.
I want to leave these here for y'all to look at so that you can look at everything. When you're finished with them, if you care to look at them, if you will bring them back into chambers for me. Because I have seen some of them. I've had time to read some of them this morning, because I've been quite as busy as you two have as far as running around trying to get your witnesses and everything together. So if you want to just make sure that you've had a chance to look at everything, once you're satisfied that you have, if you would bring this file back to me, and then I'll finish reading. Because some of the letters I've read this morning, some of them I've not had time. I want to make sure that if somebody thought enough to send me a letter that I've read.
Your Honor, for the record, I would ask, and with all due respect, Dr. Clark, I know this is terribly traumatic, and we get it. My client understands that. With due respect to my good friend, Ms. Clinton, the fact she's relaying what Ms. Carter Maryland, I feel all that, and that's not in the victim's impact, and I can't cross, I'm in a tough position, so if she could update her victim's impact, I don't want to put any more stress on it than we have to, but
What about this? As I said, I'm going to go look at and I'll take this. What about if you, Ms. Clemens, and Dr. Clark sit down and talk? Is she here?
She is here, Your Honor, but I don't know that that would be fruitful if the court want. I don't know if it's because this is a courtroom full of people, if the court would want to speak with her in chambers, like we did with Baker this morning. But I don't see that me, Mr. Ray, and Dr. Clark, that would be a fruitful situation, because the answer, in my opinion, would still be, I don't know. I'm conflicted. That's me speaking for her. The state is not conflicted, again.
Right. Okay. Do me a favor, humor me.
Yes, sir.
Yeah, try it and see. My concern is the court can justify, under the tender years exception, having Baker Imes back there talking to him in y'all's presence. But Dr. Clark doesn't satisfy the tender years exception. And I understand it may be that she'll never be able to say what she wants to happen in this case. And in that case, then I'm going to go through it and do what I've got to do.
And Your Honor, to be clear, this is not just about Dr. Clark and Mr. Clark. There's obviously an emotional entanglement.
Sure.
We have a room full of people, full of very strong opinions on this subject.
Right.
And the fact that she is conflicted is a source of deep shame for her.
Right.
And so that is part of why, when she takes the stand, she has a hard time speaking, because there are people out there that love her, that care about her, that want the person that did this to her to never see the light of day again.
I understand.
And so for her, that pressure of those who love her and care about her causes her to be ashamed and embarrassed, and here we are.
Y'all heard this speech before. When I sentence someone, I have 4 things that I'm concerned about. Punishment, protecting society from whatever behavior it is that I'm sentencing for, deterrence, and rehabilitation. And those are the 4 things that you sort of look at. And I try to. And I told you that it's no secret, and I've said it last week and I said it today. The court's concern at this point in time tends to be not everybody out there, quite honestly, but that gentleman sitting right there in Dr. Clark.
The issue, Your Honor, from the state's perspective is that domestic violence is different.
Right.
It is different. It's a different animal than any other case, and that we've seen it time and again where what a victim says to police the night it happened ends up being very different than what they say when they come into court, because there is an emotional entanglement.
I understand. I had one last term. She didn't want to come up. Prosecutor, defense lawyer, and I went back in the chambers. We called her. She lives somewhere in South Mississippi. She said she wanted him to serve some time, but she didn't want him to serve a lot of time. She wanted him to be she wanted him to serve some time in jail. That's what the court did. She didn't want to come up and get on the stand and testify. So I understand all of that. But as I said, the court wants to be fair to both. One of the things that's mitigating in this case is Mr. Clark pled guilty. He was here back in May. He said, "Judge, I did it." And I'm ready to accept whatever punishment that you felt like. And that's mitigating. He didn't have to go to trial. No one had to get on the stand in front of the jury and all of that. There's other mitigation in these letters, and there's aggravation in these letters. Just see if you two can talk to her and kind of give her an idea of what it is that she would like. And it may be impossible. I understand that. And if you come back and say, "Judge, it's just impossible," that's okay. That's okay, I understand. I'm gonna take a short break. I'll take the file and these exhibits, and then y'all can report something to you about that.
Yes, sir.